Hello, everyone. Just a reminder that this session will be recorded, and we will put any questions and comments in the chat box, and we will address them throughout the presentation. Scott, you can share your screen now.
On January 16th, 2013, Emily Giles was sent home to die. She suffered from dementia. She had Alzheimer's disease. She experienced hallucinations. She was inactive. She was not eating. She was 95 years old. And it was her time to go. See, at one time, Emily was successful in business. She had worked at Johnson & Johnson. She had acquired a large sum of money that she had accumulated over several years. And the doctor consulted her, along with her caretaker, Janet Wagner, about the deteriorating health of Emily. Janet, a few days later, went to a law office, had a power of attorney drawn up, and within weeks, Janet attached her name to 6 of Emily's accounts. She cashed out 4 CDs that belonged to Emily. She began spending, and she began spending a lot. See, with this power of attorney, Janet thought she could spend her money or spend Emily's money however and whenever she wanted. And that's exactly what Janet did. After Emily was sent home to die, that was when Janet's spending grew. She put new gravel in her driveway. She remodeled her kitchen. She purchased several storage buildings that you see here. She purchased a new generator, a new car. Specifically, she purchased a 2011 Nissan Rogue, a 1998 Ford Ranger, and a 2004 Nissan Pathfinder. All of this was purchased with funds that belonged to Emily, and it was all purchased over a span of 4 months. Janet had spent $138,000. She had written checks to cashed them, and then used that cash to execute all of these purchases. Shortly thereafter, Emily was placed in hospice by Janet, and in May of 2013, Emily died. Ladies and gentlemen, to help tell this story, particularly to help tell this story to a jury, we have to have access to financial records. We have to have access to the financial records of the victim. We have to have access to the financial records of the suspect. And we also have to have access, maybe in this case, to the financial records of third parties who may be involved. And when we obtain those records, we need to review them. We need to organize them in a way that we can successfully prosecute the case. I just want to make sure, can everyone hear me at this point in time? I'm showing up that Pam still has her microphone on.
Yes, we can hear you.
Okay, great. Thank you, Pam. Folks, my name is Scott Harket. I'm a special prosecutor with the North Carolina Conference of District Attorneys, and I'm here to talk with you today about accessing and organizing records in elder abuse cases. I do want to thank Laura Schlebach, Allison Crossman, and Pam Palmer for inviting me to take part in this event and for their help and professionalism and making sure myself as well as other speakers are well prepared for a well-run virtual event. During the course of this presentation, I want to cover a few objectives. First, when we talk about accessing bank records, we want to make sure that we access those records legally. We want to ensure that these records are usable, and not only that we can see these records during the course of our investigation, but that we can present them to a jury. Once we get these records, we don't just want to put them in a desk and let them sit. We need to be able to use them. And in order to use them best, we need to know how to organize them efficiently. As we talk about accessing records and organizing records, we also want to make sure, or I want to make sure during the course of this presentation, that I provide you folks with some practical tips. I hope to provide you with something that you can take back to your DA's office, your police department, or your organization, and that you can use it, you can apply it, and you can make your job easier. So first, let's talk about accessing financial records. The important questions that we need to ask ourselves before we start the process of accessing these records are, first, where are we and what stage are we in the case? Are we in the investigation phase or the pre-charge phase? Or has the case already been charged, or the defendant has already been indicted? Are we at that phase of the particular case? The second question we need to ask before we decide how we're going to obtain financial records is we need to ask ourselves, whose account information are we trying to obtain? And during the course of this presentation, I'm going to make the mistake of saying the defendant's records or the victim's records. And that's not really how we should look at it. Whenever we talk about bank records, those records belong to the bank. They don't belong to the individual. So I'm going to try and refer to it, as you see here, as account information. And I'm sure I'll make a mistake or two along the way. But we do need to ask ourselves whose account information we're trying to obtain. Are we trying to obtain the account information that belongs to the victim? Are we trying to obtain it, the information that belongs to the suspect if we're in the investigation or pre-charge phase, or if we're post-charge, post-indictment, being the defendant? Or are we trying to obtain the account information of a third party? Folks, if we don't ask the right questions, we're not going to get the right answers. And the answers to these questions are what is going to lead us to the best possible way, or as I'll refer to it, method to obtaining records in older abuse cases. Before we really dig into the Financial Privacy Act, I do want to talk a little bit about its history. The North Carolina Financial Privacy Act was passed in 1986, and it was done in response to a Supreme Court of the United States opinion in United States versus Miller. That case, decided in 1979, involved a group of law enforcement officers in a federal case where they discovered a 7,500-gallon capacity distillery and 175 gallons of non-tax-paid whiskey. 2 weeks later, as part of their investigation, the government served a subpoena on the defendant's banks. The subpoena requested the banks to produce, quote, all records of accounts, i.e. savings, checking, loan, or otherwise, in the name of the suspect. The banks produced these records to the government, and the defendant was ultimately charged with operating a distillery without paying whiskey taxes, possessing untaxed whiskey, and conspiring to defraud the United States of America. During the course of the defendant's case, he made a motion to suppress these financial records, particularly checks and deposit slips and other records related to the accounts at these two banks, stating to the court that these were obtained in violation of his Fourth Amendment right against unreasonable searches and seizures. the Supreme Court reasoned that these financial records were the property of the bank, not of the defendant. They were the property of a third party. And since they weren't the defendant, the depositor, they were a third party, there is a reduced expectation of privacy. And the defendant, therefore, had no standing to allege a Fourth Amendment violation, and no Fourth Amendment violation had occurred. In response to this, Congress, as well as several states, created the Right to Financial Privacy Act. It was put in place to provide safeguards against government intrusion. It provided standing to folks like this defendant if those safeguards are not met by the government. And it established various methods by which the government must use in order to obtain someone's financial records that are held by a financial institution. In other words, Congress and our local legislatures didn't want government to just be able to go into anyone's bank account at any time and get any of their records. So they passed these Right to Financial Privacy Acts. As I mentioned earlier, in North Carolina, ours was passed in 1986. And as a general rule, it states that no government authority may have access to financial records unless they are obtained in accordance with 53B, which is our Financial Privacy Act. It requires that the government authority must describe the records with reasonable specificity. In other words, you can't just say, I want any and all records of John Doe. You probably also can't say, well, I don't want all the records, but I want A, B, C, D, all the way to Z. You have to be reasonably specific in your request. And so I think you probably need to specify with date ranges or the types of records that you are seeking. Additionally, the government must seek these records and seek access to these records by one of the 13 prescribed methods that are enumerated in 53B-4. And that's what we're going to spend most of our time discussing today. The good news is that there are only 6 methods that apply to us when we're talking about investigating older exploitation cases. First, one of the ways that's enumerated in the statute is where there's suspected financial exploitation of a disabled or older adult. Next, these records could be obtained by consent. In our instances, likely by consent of the victim or through a consent of their attorney in fact, power of attorney, or guardian. Another method that's enumerated in the statute is when they're obtained via search warrant. We're going to talk a little bit about search warrants, their requirements as it relates to financial records, and hopefully some practical tips as we analyze that method. Next is a subpoena. We're going to talk about when it's proper to use that subpoena. And also, in these cases, especially when you're trying to get financial records, you can't just say, oh, we'll send a subpoena to the bank and we'll get them. You're going to have to provide notice. You're going to have to meet some requirements, and we'll discuss those a little bit. Also, they can be obtained. Another method is through a court order. Or lastly, and really very closely related, would be where there is pending litigation between the individual's records you're trying to obtain and the government authority. Remember, all of these methods will have their own requirements. So don't just think, oh, I can just seek a court order. You really need to meet all of the requirements that are enumerated in 53B. You have to follow the particular procedures, and you have to do it in a way that satisfies the Financial Privacy Act and other relevant North Carolina law. But before we select any of these 6 methods, we always need to keep in mind those 2 questions that I mentioned at the beginning of this presentation, because those 2 questions are going to lead us to the appropriate method that we're going to choose. 1, where are we in the case? And 2, who financial information are we trying to obtain? So let's first talk about the first method that applies in our cases. I am not going to cover the emergency intervention under 108A-106. I am aware of that. That's where under particular findings and after a petition by DSS, a court may permit the inspection and freezing of a disabled adult's assets. This statute and sample motions and orders are in your materials. However, I'm not going to cover this process during the course of the presentation, but please know that it is available to you. As we look at suspected financial exploitation as enumerated in the statute, it states that whenever someone is investigating, a government authority is investigating a credible report of financial exploitation of a disabled adult or an older adult, either the county Department of Social Services or a law enforcement agency may petition the district court to obtain relevant financial records. And that is shown in 53B-413. So what do we need to do? We need to follow the statute 108A-116. We need to petition our district court. We need to request that the district court issue a subpoena for these financial records. It needs to be filed in the county of residence of the disabled or the older adult, and the case must be heard by the district court within 2 business days. This is how you practically go about obtaining records under this method. The problem that I see with this method as a prosecutor is you must file it in the county of residence of our disabled or older adult, and we must do so in district court. But a district court judge's jurisdiction is only within their district, whether it be a single county or just a few counties. And if our financial institution doesn't have a presence in that judge's district, particularly they're outside of the judge's district, you may need to look for a different method, one that allows you to maybe go to a superior court judge whose reach is throughout the entire state. So whoever drafted this statute, I don't think did a good enough job to guide us regarding the district court's jurisdiction when they issue these particular subpoenas. So just keep that in mind. Now, when the district court gets the petition, they shall issue a subpoena for these financial records if the agency is investigating a credible report that the disabled or older adult has been financially exploited. And again, this is the local DSS or the law enforcement agency. The court shall issue the subpoena if the disabled or older adult's financial records are needed to substantiate or elevate the report. And lastly, time is of the essence in order to prevent any further exploitation of that disabled or older adult. And the court must make these findings in their order. The good news is AOC forms already exist for this petition and for this order. As you can see in the top right, it states petition and order for issuance of subpoena, directing release of financial records. It cites General Statute 108A. 108A is then cited in our Financial Privacy Act. So we know that we're going to meet all of the requirements necessary to follow the Financial Privacy Act, to follow 108A. And we not only have a petition here that the government authority can make, but we also have an order that is drafted and all the check boxes are hit. It's filled out by that district court judge. And it's important to note, it is the court that's issuing the subpoena. So it's not the attorney. We're almost 100% of the time going to be pre-indictment, pre-charge when we use this. And so an attorney's not going to be able to issue that subpoena. You know, attorneys in North Carolina do have subpoena power, but a subpoena cannot be issued by an attorney without a pending case. And we're going to talk a little bit about that later on when we get to the subpoena section. So that is the first of our methods, and probably the most widely used that we're going to use when we talk about older exploitation cases. But let's just say, for instance, we don't have enough information to meet any of those three requirements. We're not at a good stage in the case where that's an appropriate method. Then we need to look for other methods. And the next of those methods that we're going to cover is consent. It's also referred to as customer authorization, and it has requirements as set out in 53B-4. First, this consent must have an expiration of fewer than 3 months. In other words, you can't say consent to letting me look at your financial records for eternity. That's just not available. We need to not only needs to have an expiration of 3 months, but it needs to be in the document that you're obtaining consent from the record holder during that period of time. The consent also must state that it can be revoked by the account holder at any time. It must identify those records that are to be disclosed, and it must specify the purpose for which the government will use these records. And lastly, it must restate the customer's rights under the Financial Privacy Act. And that method is listed in 53B-4, subsection 1. This is the consent form that the State Bureau of Investigation uses during the course of their cases. They do a phenomenal job. This is in your materials. I encourage each of you, whether you are with DSS or a law enforcement agency, to take this, to copy it, to use it, to make it your own, put your logo and letterhead on it, and steal it, and definitely use it and put it into action. As we can see here, and we go through these, we go through each of, really, I've highlighted each of the elements that are required under 53B-4 for consent. It identifies these financial records. So it clearly states which records you're trying to obtain. Next, it states that they're being obtained for a particular purpose, and you list that purpose there. It indicates next that it can be revoked at any time before the above records are disclosed, and that this authorization is valid for no longer than 3 months from the date listed below. You see an area for the customer, the person who is consenting to those records, to sign. And then on the back of this form that the SBI uses is that statement of customer rights under the North Carolina Financial Privacy Act. So you don't need to go look it up. You don't need to go find it. It's all right here. And as I mentioned, I encourage your organization to use this moving forward whenever you're trying to obtain financial records by consent. So we've covered the first two methods. Next is search warrant. One of the benefits to using a search warrant is that you're not going to be required to give any notice whatsoever to the customer, as you would with a court order, with a subpoena, or where there's pending litigation that we're going to discover later on. I recommend that you always use a search warrant for the suspect or the defendant's account information. So when we talked about those two questions earlier, and we said, what stage of the case are we in? And then second, whose records are we trying to obtain, or whose financial information are we trying to obtain? When we are looking at a suspect or we're looking at a defendant, my recommendation, and I think the absolute best practice, is to obtain a search warrant for those financial records. Next, know that a search warrant could be executed before or after criminal charges are brought. And lastly, please, please, please keep in mind that this is a tool that is only for law enforcement. I was talking not too long ago with a law enforcement officer about a particular case that involved a really big company that was had a really big law firm that they had retained to help them with a fraud issue that they had within their company. And the attorneys the private attorneys that represented that very large business had actually drafted a search warrant to then petition a court for and then hopefully obtain. And that was the wrong way to go. And I don't know where they got that wild idea, but ultimately they got it. And luckily they were stopped before they tried to obtain that search warrant. You also may be saying to yourself, listen, I have a case in Superior Court. This case has been charged. It's been indicted. Superior Court has jurisdiction over the case. How can I then go to a magistrate and somehow obtain a search warrant? Wouldn't I need to, after they've been charged, to go to a Superior Court judge? You may also be saying, isn't this an ex parte communication, right? If the case has already been charged, I'm going to a judicial official. But let's take a deeper look at these two questions and see if they really are a problem. So in State v. Pennington, the court held that the clerk and magistrate still have jurisdiction over a case that is in Superior Court. So you can petition the magistrate for that. It's really, the court reasoned it's neither a district court matter or a Superior Court matter. It said that search warrants pertain to pretrial investigation and cannot be classified by the court where they may eventually be tried. Next, there's no ex parte problem, as the court found in Franks v. Delaware. The Supreme Court of the United States says it's necessary for search warrants to be ex parte to prevent the subject from being tipped off to any portions of the investigation. And lastly, remember, we talked about it earlier in this presentation, there's no standing by the defendant to challenge these search warrants under the Fourth Amendment due to the holding in United States v. Miller. So you're satisfying the Financial Privacy Act by using a search warrant. You're also not running afoul of the Constitution as held in United States v. Miller. There's also a great blog, I may have put it in your materials, that was written up by Jeff Welty, who was formerly with the UNC School of Government. It's entitled Obtaining a Search Warrant After Charges Have Been Brought, June 24, 2013. That is a great read. It provides you with a lot more detail as it relates to this. But no, search warrants can always, always, always be executed after charges have been brought. And we're going to use this a lot, at least as a prosecutor and dealing with my law enforcement agencies. We see it. I see it all the time, right? I receive an investigation by a law enforcement officer. There's areas of the investigation that I don't feel are complete or that haven't been addressed, or there's records that haven't been obtained. However, the individual's already been charged, already been indicted, and it's been done so without us getting these records. Or in some instances, records are going to be provided to us as prosecutors that aren't admissible in our case. We've received these printed off copies of these records that have been marked up or highlighted. They've been ripped, they've been missing pages, and they haven't been treated like evidence. There's a lot of times there's no affidavit or statement from a records custodian, and there's no way to admit these records. So the solution for us is to seek a post-charge search warrant for these records. So why do I say that we should always obtain a search warrant for the defendant's records? Well, the reason I say that is because there's no notice requirement. It's a notice requirement that a court order for a subpoena would require. There's also no opportunity for the other side to then convince a judge to not give us what we want during the course of an investigation. We just need to say there's probable cause to believe a crime's been committed and that we need to search these defendants' bank records, and we can do that. It's going to be constitutional, and it's also going to meet and satisfy the safeguards that are required by the Financial Privacy Act. The next method we're going to cover, which oftentimes and seems to most people would be the most simple, but it not necessarily is where we issue a subpoena for the financial records that we're seeking to obtain, whether that be the records of the victim, the suspect, or a third party. Note that I'm not talking about a subpoena under 108A, where we petition the district court. That was the first method that we discussed during the course of this presentation. Also note that this is not available prior to charge or prior to an indictment. As I mentioned earlier, a subpoena for the production of records may only be issued in a criminal proceeding, and that cites our North Carolina Criminal Procedure Act. Also, a subpoena is not available until an action has commenced. And this was the holding in In Re Superior Court Order dated April 8th, 1983, case decided in 1984. Also remember that you must give notice under 53B5 or 53B-6 if you are using a subpoena, and that is notice to the victim, notice to the defendant, the suspect, or a third party. So we do need to ask ourselves again, as we look at subpoenas, whose account information are we trying to obtain? And if they're the suspects, that's probably the last person on earth that we want to give notice to that we're going to be seeking their financial information. So we don't want to use a subpoena in that circumstance, and we don't want them to have the opportunity to be heard. I'm not going to cover during this presentation 53B-5 or 53-6, but it's in there. And if you have any questions on it, feel free to reach out to me at the conclusion of the presentation. So we've covered suspected financial exploitation, consent, a search warrant, subpoena, and court order. Next, let's talk about a court order. So there are two types of court orders. First, there's a pre-charge court order, which we're going to cover here. And during a pre-charge court order, we need to look at some case law. I've really put it together, and I've put together 4 requirements that we need to meet when we seek a court order prior to a case being charged. First, we need to initiate and docket this court order that we're seeking as a special proceeding. So that's where it needs to be filed in the clerk of court's office, is in special proceedings. It's not a criminal action. It's not a civil action. It's not an estates issue. So it's going to be docketed in special proceedings when we're talking about it being made in the pre-charge phase. Next, we also have to show, as prosecutors, we have to have some sort of evidence. We have to have either a sworn affidavit or similar evidence. We can't just say we're seeking the financial records of this individual in, quote, the interest of justice, unquote. We need to show and outline specific facts and specific evidence. So just boilerplate standard language is not going to be enough. We need to discuss some facts relevant to our particular case. Lastly, we need to cite, or not lastly, but next, we need to cite some legal authority to the court whenever we're seeking this pre-charge court order. And lastly, we need to meet and satisfy all of the Financial Privacy Act requirements. So these are the 4 really prongs that you're going to have to meet as a prosecutor in your motion when seeking any court order for financial records under the Financial Privacy Act. And I say that you should seek them as a prosecutor for a reason. And I know we have several folks from DSS, law enforcement agencies, and we do have a few prosecutors in attendance today. But I say prosecutor because our state bar has weighed in on the issue of law enforcement officers obtaining court orders, particularly for financial records. There are some orders that law enforcement officers may seek by statute, but a court order for financial records is not one of them. And the North Carolina State Bar has held that that is the unauthorized practice of law. And so law enforcement officers, DSS, you're going to need to pair up with a prosecutor who's going to make this petition to the court and seek this court order in the pretrial phase pre-charge phase, or even in the post-charge phase. Because otherwise it would be the unauthorized practice of law for a non-attorney to move the court for this order. So we have made it to the last of our 6 particular methods, and it is really the easiest one. And it's very similar to seeking a post-charge court order. All we do here as a prosecutor is we motion the court for the financial records we're seeking to obtain. We provide notice to the other side, and then we receive an order for the court. This is only going to be available to you if there is pending litigation. In other words, you're seeking the defendant's records who's on the other side. However, again, it's better to obtain a search warrant at this phase of the case because we're not making a motion, we're not providing notice, and we're not giving that defendant any opportunity to go into court in hopes of convincing a judge not to give us access to the financial records. So a search warrant is the appropriate play here. I have used this method, but it's not necessarily, and it's pretty simple, but it's not necessarily always the best method. Now that we've talked about the 6 enumerated methods, what may banks just provide outside of the Financial Privacy Act? What's okay for banks to give to government authorities? Well, they can always provide the name, the address, or the existence of an account to law enforcement, but it must be requested by law enforcement in a written form. And so, if you want more information, the name, address, and the existence of an account, you're gonna need to use one of the 13 methods. But this is a great example, and I don't know if any of you folks are involved, but the bank watch groups. I have a local bank watch group that's, I think, based out of Guilford County somewhere, and it's where banks and law enforcement officers share information, but they share information pursuant to written email requests that are sent on this chain. That information is then sent out to various financial institutions, and they're basically asking, is there an account with so-and-so's name on it, so-and-so's address, and so-and-so, do you have one, and what are they? And these banks and financial institutions can legally provide this information to the government, to law enforcement, and law enforcement and the government can use it as a tool, right? Because now they know where to go to get this information and additional information pursuant to any of the methods that we talked about. Also, when it comes to disabled adults or older adults, banks shall provide particular information. Financial institutions have a duty to report to law enforcement when they have reasonable cause to believe that a disabled adult or older adult is the victim or target of financial exploitation. Also, they have a duty to report to the appropriate county Department of Social Services if the customer is a disabled adult. So that doesn't extend to older adult. Obviously, a lot of times there is some overlap, but note that it's a duty to report rule. This is not a rule that says they have a duty to provide the records. So if you do have this tip from the bank and you're a law enforcement agency, you still have to make sure you follow some of those methods, at least one of those methods that I described earlier in this presentation, to get your hands on the actual financial records that you're going to use. The next thing I want to talk about when we talk about obtaining and accessing financial records is something that's very, very important to us as prosecutors that a lot of times investigators don't realize or don't recognize. And they shouldn't, because they're not the ones in the courtroom who are having to try the case and abide by the rules of evidence. But us as prosecutors, we have to make sure we not only have the financial records, but that it's going to be admissible in court. And so I say that we can get all the records all day long, but if we don't have a witness, or if we don't have an affidavit signed and authorized, signed and notarized by the custodian of records at that financial institution, there's no way we're going to get those records before a jury. And so I say to you, it is a great, great idea to always get a witness, get a business card of whoever you've talked to at the financial institution, and always get an affidavit and make sure it accompanies the records whenever you receive them. This will make those records comply with 803.6 and 902.11. Those are our rules of evidence. And then as prosecutors, we can give notice to the other side that we intend to use an affidavit to get these records into evidence. We don't even need a witness. We just have an affidavit that looks similar to the one here on the right. And there may be one in your materials as kind of a go by, but each of the financial institutions, they're getting better about it nowadays because they don't want to send witnesses to court. They do a pretty good job of making sure records that are disclosed to us are accompanied by this affidavit. But there are several instances, even within the last few months, where I've received records and they didn't include this affidavit. So once you get them, you always need to make sure that they are accompanied by an affidavit. So when we talk about accessing, we need to talk just to cover, in summary, what are the best practices? We need to ask our two questions. What stage of the case are we in? And whose account are we trying to obtain information to? And then we need to pick the best particular method. We need to get a bank contact. We need to request an affidavit from a records custodian. And then when we get the records, we need to treat them like evidence. We don't need to mark on them. We don't need to highlight them. If we're going to do any of that, make another copy of it, and we can do it that way. But we really need to treat them like evidence to ensure that they're going to be admissible in a jury trial. So now that we've talked about accessing records, I do want to talk briefly for the remainder of the presentation about organizing these records. Let's talk a little bit about how to get the documents and what to do when we get them, and then how to organize this data after we've received the documentation. So when we serve our search warrant, our subpoena, whatever we're using, court order, we should always attach a cover letter to it. We should request an affidavit from the financial institution. We should get a business card of somebody, whoever we served it on, and make sure that is documented in the file. And our preference is really to request electronic documents. We don't want these big, voluminous binders of information. We want them to be electronic, and we want them to hopefully be organized whenever we receive them. So I've talked a lot about the affidavit during the course of this presentation, but I do want to just kind of cover a little bit of an example. We have our law enforcement officer. This is our victim business, or in this case, this building over here is going to represent, I guess, a nursing home, since we're talking about older exploitation. But if we're talking about a business as a general example, our officer will generally go to the business and say, hey, I need all your records. And the officer will come back to the prosecutor, bring the box full of records and say, hey, look, I've got all these business records of the victim. And the prosecutor's going to say, well, I need a witness. And so they're going to have to bring somebody over from the victim business, or if we get an affidavit that accompanies those records and they are the records of the business, then we can use that affidavit in lieu of an individual to testify. This really isn't going to work for our victim in an older exploitation case, because they're not a business. They aren't going to be business records, and they aren't the records of the victim. They're actually the records of the bank. So we need to have our law enforcement officer, and this is just an example. This is like bank statements going to our victim, and then the officer takes those bank statements and brings them to the prosecutor. That's a problem because we need our officer to go to the bank, get the records directly from the bank, have them be accompanied by an affidavit, bring them all to the prosecutor, to the courtroom, to the courthouse, and that way they'll be admissible before a jury. Or we can bring an individual from that financial institution in to come in and testify. And that way, our bank records will be admissible. When we receive them, we need to review them as investigators. We need to make sure we have everything we asked for, because banks make mistakes, and they make mistakes a lot of times during the course of this production. So we need to make sure if we requested checks, deposit slips, and statements, we need to have all of that. We need to make sure it covers the time period that we've requested. We need to make sure we get that affidavit, and then we need to scan if necessary. If you're going to scan them, use OCR. That allows the document to be searchable. Use at least 300 DPI when you do it. Note that when you scan documents, the highlights typically will not show up. And using OCR is just a big, big benefit whenever you're dealing with a lot and a large volume of records. Also, when we have scanned them and we're reviewing them, we should use bookmarks. And we should, if you're familiar with that, if you're not, and you have any questions about it, feel free to reach out to me. But you need to bookmark that document, and you can bookmark, bank statements for a particular time period. That way you can go on the left side of the screen, you can click and be where you want to be instead of sifting through thousands of pages of documents. Also, we want to create summaries, and we want to create these summaries, and if possible, we want to have the victim do it. I know in older exploitation cases, that's not always going to be the case, but if we can have the guardian do it, or somebody who really has some experience with the particular transactions or with the knowledge of what has happened, this can be very helpful. It can also give you more time to do other things, but oftentimes you're going to have to be the one to do it. And so you can either type out the transactions yourself, or you can use some type of conversion software if necessary. You can highlight all the transaction details. And then this summary, as a prosecutor, would either be admissible in court as a pedagogical device summary under Rule 611A, or as a Rule 1006 summary. So for example, we have a bank statement, and if you take it and you place it into some of this conversion software, there's several that exist, CogniView, MoneyThumb, and many more. It will then turn it into a spreadsheet like this that you can use and manipulate and make into an efficient summary that would be tailored to your particular case. This is an example from CogniView, that software that is widely used and available. So when we analyze and look at these bank records, what should we look for? Well, we should look for any other account information, any information of other accounts that you think we should dig into, right? Or where we think or see money is going. And then we can use one of our 13 methods to hopefully obtain the financial records of that account if it's necessary and we have reason to believe it's part of the criminal conduct. We want to look at all of these transaction details. We want to see the location of where that transaction occurred, right? If we have an elderly victim who we know is not traveling to the Bahamas, then, and we see transactions on that account in a different location like that, those are things that we need to analyze and look at and say, maybe there's a problem here, and we need to really dig in on those. Also, look for order numbers. Use that information. Look for purchase information to see what types of things are being purchased. And probably most importantly, I think, is to look for where things corroborate. And I say internal corroboration and external corroboration here because when we talk about internal, within the bank documents themselves, right? We have money going out via check, and then we have another area of the records that shows that that particular amount of that check was deducted from the balance. And that's just going to be very, very helpful in painting that picture for a jury and them being very, very sure that the records that we have are going to be accurate, and so forth. Also, when there's a large sum of money transferred into a particular account, and then we see several checks moving out after that square up with whatever that large sum of money was, that's going to be very helpful internally. But then when we look at external corroboration, we see a wire of, say, $5,000 from an elderly victim's bank account. Then we can look at the suspect or the defendant's records, or excuse me, their account information from their bank, and we can see a $5,000 deposit being made at that particular time. So those are good things that when you have these records and you analyze them and you're organizing it and putting everything together, that is very, very beneficial for you to look for. I can't tell you how many times I've had cases where financial records have been provided to me by investigators and they've never looked at them. I know it's a lot of information and it takes a lot of time, but I try, at least as a prosecutor in every case that I have, when I first get it, to always go through all of those bank records and at least just flip pages and see if anything stands out and tab them or bookmark them in Adobe if that's the way we're going through, so that we know several months down the line, several months later, as we're putting all of the pieces together, that that's a piece to the puzzle that we need to make sure we highlight throughout the course of the case. Note that when you get information from these banks, there is a wealth of information. This is just one check. And this one check is a check that was written from a victim business in this instance. And in our cases, it would be written out of possibly an account of an older adult. But we see a large sum of money. But if we look at the back of the check, these numbers down here, just to the left of this lock, it looks like, those are numbers that are going to tell you, FMB. It looks like to me that's Farmers and Merchants Bank. And so if you take it to Farmers and Merchants Bank, that's likely the bank of our suspect, right? It's going to give you the date, the time. Oftentimes, it will even tell you the branch or the particular teller that the individual went to. So there is a wealth, in addition to all the information on the face of the check, the memo line, the check number, or even the documentation outside of the check. When we flip it over, there is going to be a wealth of information that our financial institution can decode for us as we work toward tracing these funds. We can maybe find additional accounts, and hopefully it will be better for us as we pursue our investigation. So that's a little bit about organizing. We talked some about accessing. In summary, I do want to say that we need to caution ourselves, right? When we talk about financial crime or financial exploitation, I've been doing this for 8 years, and I've exclusively done white collar crime for that time period. And all I ever hear about is follow the money, follow the money, follow the money. And that is absolutely true. That is absolutely something that we need to do. So for every financial crimes case, it is important that we follow the money. I agree. But if we spend all of our time following the money, we're going to lose sight of the second and a lot of times more important thing that we need to be investigating. It's something that I didn't talk about here today. All I talked about and bored you to death with was about financial records, how we're going to get them, and how we're going to organize them. But we always, always, always have to keep in mind in every investigation the relationships between the people involved. Additional evidence gathering, witness interviews are required to establish this. And without understanding the relationships of the people involved, we have no case. Interviews, like I said, have to be conducted. If there's a power of attorney, we need to get a copy. We need to read it. We need to review it. When we're talking about older adults, we need to get their medical records. We need to learn more about them, and we need to document this because it is the other part of the story that is vitally, vitally important. We also, as we look at these cases, a lot of times investigators are geared toward only looking at a violation of our elder exploitation criminal statute, right? But don't think so narrowly. I think we need to think and look for other criminal statutes that may be at play. The case I talked about at the beginning of this presentation, to me, to you, to anyone at first, first hearing about those facts is really going to look at, wow, this is an exploitation of an older or disabled adult all day, every day. And that is exactly right. But that case was charged as an embezzlement case. Now, we also charged the older abuse and exploitation counts as well. But as a embezzlement case, that case carried with it significantly more severe punishment because of the dollar amount that was taken from that victim. And ultimately, we were able to send that individual to prison for a substantial period of time, something we maybe wouldn't have been able to do if we only charged, these class G, H, and I felonies under the elder exploitation statutes. So please, please, please don't narrow yourself to only the exploitation statutes. Folks, this is hard work, what you all do. It's not for everyone, but there will not be much more in this life that is more rewarding than investigating and ultimately being successful with an older exploitation case. I mean, really, there's nothing more rewarding than helping those who really don't have the ability to help themselves. I want to thank you all for your time today, and I want to thank you all for what you do to pursue justice and to help prevent older abuse here in the state of North Carolina. Thank you.
Scott, thank you so much for a fabulous presentation. We do have one quick question before they take us back to the main thing. How long do these orders take to be issued by court typically, and what protections might you pursue while in progress? And I'm thinking they're talking about the release of financial records.
Yeah, thanks, Pam. So I think I'm not certainly clear on your second part, but I think as far as making that petition to the district court, district courts, and I'm talking pre-COVID here, and hopefully we're getting out of that, but they run, quite a bit, right? I mean, district courts run almost every day, all day, every day. So there shouldn't be a problem getting, that petition before a district court judge for them to sign off on it. And then you just take it, serve it on the bank. So that could be done in a matter of days. I mean, the hearing requirement is within 2 days. So I don't necessarily think that's a problem. I think the other part of your question may have been geared toward, freezing or seizing those assets. And as I mentioned earlier in the presentation, that is under another portion of the statute in 108A. And if they look at that, that's a good way to really, at least as far as the victim's records are concerned, make sure they're frozen so that our suspect isn't taking any more money from our victim while we're investigating the case.
Great. Thank you again. And just everyone know that the slides and the recording will be on the website. Thanks, Scott.